14 on file with the Board of Appeals, seeking a special permit from the terms of Section 3810 of the zoning bylaw, seeking to be permitted to employ persons not residing at 108. This is Governor's Road, but it's 108.
3 St. Mary's.
Well, it just says Governor's Road. Residing at 3 St. Mary's Road in Milton, which is located in a Residence C district. The zoning bylaw, Section A, 3810, small b in parentheses, provides that only persons residing in the dwelling may engage in a home occupation. My name is John Leonard. I'm chairman of the Board of Appeals. With me tonight, to my immediate left is board member Emmanuel Alves, and to my immediate right is board member Nicholas Gray. I think we have the first time in my history serving on the Board of Appeals where we have 4 hearings tonight, and they're all represented by the same distinguished counsel, Mr. Ned Corcoran. So we'll try to soften some of the formalities, because I'm not going to go through the same preamble for each of the 4 hearings where we have people who present represented by Mr. Corcoran. But the rules of the board are such that we'll first hear from the applicant, then we'll hear from people who want to speak in support of the application. We'll hear from people who have questions of the applicant, or Mr. Corcoran, or people who want to speak in opposition to the various applications. We're tape recording the meeting this evening, so that would ask that before anyone speaks, tell us your name and address. Speak up nice and clear and loud so we'll have an accurate record of the proceeding. If we have to revert to the board, strike it to the tape recording to write a decision in this case. So basically I've outlined the advertisement. We have the application in evidence. It's dated August 2014. We have a denial, a notice of violation technically by our building commissioner, Joe Prondak. It's dated July 22nd, 2014. We also have, as part of the record here, an addendum to the application for a special permit prepared by Attorney Corcoran, citing the requested relief and the reasoning that he believes warrants the special permit to be granted. And we also have a letter, which I don't know is directly pertinent to this particular application, but it's dated 7/7/09. You have that letter as part of your materials, Mr. Corcoran. And it's basically it's an enforcement letter that Mr. Prondak sent to Liz Page at 3 St. Mary's Road in 7/7/09, requesting her to cease and desist from operating a business where the employees do not reside in the premises. And Mr. Corcoran, I'm sure, will tell us what happened to that particular matter, if anything. Lastly, we received 1 letter on this application. Have you seen this letter, Mr. Corcoran?
I did, and I have others to present to the board that I've received as well.
Okay, well, let me just read this one, because this is what I have in my hand. This is a letter. It's dated September 15th, 2014, to the Board of Appeals, and it's from Ann Dolan. And Ann Dolan says she's a 35-year resident of St. Mary's Road, and she requests that the Board of Appeals enforce the zoning bylaw and not permit employees not residing at 3 St. Mary's Road to engage in the home occupation. She says that the employee parking impacts our Residence C district. So we thank Ms. Dolan and Mrs. Dolan for her letter. We'll have that as part of the evidence. So Mr. Corcoran, without further ado, welcome back to the Board of Appeals.
Thank you, Mr. Chairman.
And we'll be delighted to hear from you.
Thank you, Mr. Chairman and members of the board. I appreciate the opportunity to be back. My name, for the record, is Edward Corcoran. I'm an attorney based in Quincy, Massachusetts, so I do a lot of zoning and permitting work here in Milton, and as you know, I've been before the board on numerous occasions. I am joined by Elizabeth Page. Ms. Page lives at 3 St. Mary's Road, and she operates and has operated a business under the name of Liz Page Associates. It is an event planning business that is operated from the premises at 3 St. Mary's Road for about 10 or 12 years. She purchased the property 12 years ago from the estate of Dr. Conway, who lived and resided and operated his medical practice from that location for many years. The reason that she purchased the dwelling is because it was set up ideally as an office, with the first floor set up for a reception area, a doctor's waiting area, and we understand that Dr. Conway over the years employed several outside employees, including a nurse, receptionist, and others, at a time before the current bylaw was in effect. But Ms. Page has been there, she has operated, and she has operated with employees for the last 10 years. There was a letter that came, a desist letter in 2009. At the time, Ms. Page applied for and was granted a home occupation license under the bylaw, and then thought nothing further of it. And that was 4 years ago. 4 years earlier this year, presumably she should have, might have renewed that permit, but received a notice from the building commissioner's office that she was operating in violation of the bylaw. So she has not moved to renew that building certificate, that home occupation license, but she is operating, at least in accordance with the determination of the building commissioner in violation of the bylaw.
Could I ask you one question,
Sure.
Mr. Corcoran? That is, when Ms. Page received her home occupation license, from whom did she receive it?
The town clerk.
Okay, there was no proceedings before the board.
No, and the home occupation bylaws really is a registration bylaw that allows those who would conduct home occupation to register with the town, pay, I think it's a $50 fee with the town. It gives the town the ability to understand who is operating from a business perspective in the town, to generate a little bit of revenue with respect to that, and to pay attention to what's happening. In fact, Ms. Page did not even begin to think about registering until she came to the town to register several years ago as a women-owned business, so that she could begin to take advantage of the state and federal contracting opportunities for her business. She has, as I say, operated with employees since.
Right, could I ask you, at the time that she applied for her permit, did you say that was 2004?
That was 2009.
2009, okay.
No appeal was filed.
Was there any issue raised either by the town clerk as to whether the employees were residing with her or not residing with her? Was it a non-issue?
Apparently it was a non-issue.
Was it disclosed in any filing or application that the employees were not residing in the premises?
I don't know whether there was a disclosure or not. I know that she applied and she received her license. I don't know whether.
I don't remember.
Yeah.
You have a copy of the application that was
I
filed
don't
with
have
the
a
town
copy
clerk?
of that. No, I don't.
Okay, I'm sorry. Why don't you continue?
That's fine. So I think the issue clearly is, as I understand it within the neighborhood, is with respect to employee parking. The business is a small office. They plan and run events for large charities. They run events at the convention center, at the Heinz Convention Center, at Boston Garden, and other similar venues. They do not receive or entertain any of their clients within 3 St. Mary's. Any meetings they have with clients are conducted at client offices or on the telephone. They do receive, as many home business would receive, UPS or FedEx or postal deliveries, but with the exception of those deliveries, they don't receive any other material. They operate essentially 9 to 5. They do not operate early mornings, evenings, or weekends. And they have ample parking for the employees who work there, who come there on the premises. I have some photographs that I would introduce two photos, there's a, let's see, four items stapled together. One is a download map from the town's website of the neighborhood, an aerial photograph of the neighborhood. I have a larger, and I have copies to hand out. And then I have two photographs, really of the front of 3 St. Mary's, and then 3 St. Mary's and 7 St. Mary's next door. And they depict, there's a vehicle depicted in the driveway, that's 3 St. Mary's. There are in fact 2 side-by-side driveways on the property, room for 4 vehicles to park. And the employees park there generally during the day. Occasionally we'll park on the street, but generally park there. And as a condition of any approval, if the board would determine to do so, would agree that all vehicles would park there. But there is plenty of parking on the premises for their cars.
And what's the total number of employees?
3. So I have a handful of copies.
Who are you looking for now? This is the Cronin room. You looking for the Board of Appeals? Oh, sure. I'm sorry.
So I have copies of those. I'll hand out copies to anyone who'd be interested in.
Great,
Thank you.
Right. And so the issue in the neighborhood, I think as it boils down, is really parking and availability of parking during the day. And the significant traffic generator in the neighborhood is St. Mary's Church, which is essentially two doors down and across the street. And if you can see from the aerial, St. Mary's Church has 7 parking spaces off-street. And there are daily functions, masses, funerals, weddings, other things that go on at the church, and there is a free-for-all for parking that occurs every single day. I have a series of letters that support Ms. Page's application, including one from Reverend Arthur Wright, who was the pastor of St. Mary's Church. And it would,
He's busy.
he was,
Yeah, do you have him for dinner or something? He writes letters on almost all your applications, Mr. Corcoran.
well, he is an abutter of a couple of my,
fan
couple of
base.
these matters. And
But obviously, we thank the Reverend Wright for his participation in the public process, and we don't mean to make light of it, but it's just,
no, it's clear. I mean, the major traffic generator is the church. And I think to the extent that if there were a business and there was conflict of parking because customers were coming or employees were parking on street and churning up those on-street parking spaces, then I would suggest we'd certainly have an issue. In this case, I'm suggesting that there is no parking impact that comes from this operation, and that it can operate with those employees without that impact. The last point that I would make is that while we're asking the board to consider varying the language of subparagraph B of this section, we're not asking for variance. This is not
well,
something.
I noticed that. That was pretty conspicuous in your application.
I'm simply asking to vary the language to allow employees to continue to operate in this business within the dwelling. This is a license and permit process that has to be renewed on a 4-year basis. It's only good for 4 years. It must be renewed, and so it is limited in its time and its term, and it certainly would be limited to the operation of the business by Ms. Page and Liz Page Associates from that location. It wouldn't run with the land, it wouldn't run to a new buyer, it wouldn't run for longer than that term. So
Let me, quick question on that point. So in 4 years, assuming this is granted and the business certificate issues, you would have to come back if you wanted to continue. Okay, and one more follow-up. You said 3 employees. Does that include Ms. Page?
no, she lives in the dwelling and engages in the operation. I think you can make it technical. The wording of subsection B, I think is a little loose in the terms of only persons residing may engage in the occupation. It doesn't limit to the hiring of other employees. I think it'd be difficult to make that the case, but
No, but read the second part of that clause, because that's actually why I'm asking. No more than 3 persons engaged.
I would say that more than 3 persons who live in the home would be allowed to be engaged in occupation. We do have 3, as a matter of fact, there
I
are
understand
3
your position.
employees, and then Ms. Page. So the varying of the language would be to allow those 3 employees to work for Ms. Page in that premises. With that, turn it over to any questions or other comments or concerns that the board may have.
Yeah, I do have a couple of questions, Mr. Corcoran. Let me ask you first, somewhere in the bylaw dealing with this section, it limits the space in the dwelling to 400 square feet, and it says there's supposed to be plans or other things. Do you have any plans showing the?
I don't have plans
400 square
with me. I think it is approximately 400 square feet. There were plans that were submitted 4 years ago to the town clerk. I didn't bring new plans. I apologize for
No, that's
the
not.
board on that.
But your opinion is that that's what they are doing. They're occupying about 400 square feet for the home occupation. Okay. Let me ask you this, and I guess I think the more pertinent question is not parking, to be frank about it, though everyone may be interested in parking. I think the more pertinent question is what the bylaw provides. And I guess let me ask you this open-ended question. The bylaw says, quote, "Only persons residing in the dwelling may engage in the home occupation, and there shall be no more than 3 persons engaged in the home occupation." Number one, this was put into effect, I think, in 2005. Do you agree with that, Mr. Corcoran?
I think that's about right.
Yeah, May 3rd, 2005, it was approved by the town meeting, and the Attorney General approved this home occupation bylaw on June 7, 2005. To me, the real question is what did town meeting intend when they added that portion of the bylaw? Because I think you're perfectly right. I think certainly prior to that bylaw, there were many physicians and other people conducting, quote, home occupations, and I guess my question is, did the town meeting here intend to cut back on that type of use into a more gentler and home-style occupation and less of a commercial operation, such as a doctor's office or a dentist's office and that type of thing, and seeking to have more artists and quilters and that type of business? What do you see the purpose of B saying only
I think, well, there's 2
residents can engage
Right.
in the home occupation?
I was not a member of town meeting in 2005, so I don't remember the specific, I wasn't involved in the specific discussion that was taking place.
Did you do any research, talk with Jimmy Mullen or somebody who may have some knowledge of what?
I did talk to
town
some,
meeting-
none of the people I really talked to, they didn't get any helpful information. There is a separate provision in section A7I, which allows for dwellings may be used incidentally, but without public display of goods or wares or signs for sale of goods, foods or goods of home manufacture prepared therein, for the operation of telephone answering service for other incidental purposes which are not primarily industrial, trade, manufacturing, or commercial. I think this is a different type of use than has been typically a commercial use. So my prayer for relief, at least on the application, referenced that section as well. I think the purpose of the bylaw, as I understood it, was to sort of capture a whole cottage industry within the town, people who are working at home, conducting small businesses within their home, and to get them to register. And to be accounted for as businesses located within the home, to pay a small fee for the purpose of the registration. And I think, you know, the bylaw was written fairly strictly, obviously in terms of what it would allow. But I think that was the purpose, was really to sort of capture, and it didn't.
What does the permitting do if you register, but you're not in compliance with the bylaw? Where does that get you? Who cares about a registration of what businesses are operating in the town unless it's just to collect a fee, $50 or $100 or whatever they charge you?
Or to create some parameters around what you can do. Certainly there's a combination of those things. And I think it was to recognize that there were businesses that were operating, and to sort of recognize them and regulate them to a degree. So with respect to that, Liz has been operating outside of the requirements of that since before that bylaw was passed. And I think, you know, to the extent that there are others out there who may have been, I don't know, but she has been, and we're simply asking the board to recognize that she's been a pretty good neighbor, and that she would be able to continue to do so with a variance, you know, I say that with quotes, but a varying of the language in the bylaw. The alternatives,
Where does that leave the board if we buy your argument here and allow people to engage in the home occupation who are not residing in the premises? How do we deal with the next Liz Page who comes before us and is seeking that type of relief? Is it a kind of an ad hoc decision by the Board of Appeals as to whether they're interfering with the neighborhood, whether they're making noise, whether they're engaging in parking, whether the type of occupation is quiet or not quiet?
I think you really end up in a similar place.
Is that our function? Is that our function just
Well, I
to-
mean, you have a function to grant special permits for all sorts of modifications to zoning bylaws.
Yeah, aren't you asking us to rewrite the zoning bylaw when you're asking us to
No, I'm
not
asking you to treat
enforce
this as a
Section
asking you to treat this as the nature of a granting of a special permit, which is limited in time to 4 years and limited to a specific use. I'm not asking you to rewrite the bylaw, but similar to...
But don't we have to apply the bylaw consistently with everyone else who may come in tomorrow or next week?
Certainly, and you can hear whether, you can determine whether or not this operation is detrimental to the immediate neighborhood. That this is, if it's operating...
Is that really relevant when you look at Section B? We can assume everything you've said is true. I guess my question is whether Ms. Page is just not entitled to the home occupation permit because she's not in compliance with B. That's the issue. And then the issue is how do you
understand that.
draw lines if we grant the special permit here?
You would do it in the same way that you would either grant or not, or deny applications for special permits that came in from other purposes of the bylaw. You either determine
Right,
that
but do you
in a
agree with
specific
me? We
instance.
would have to take and read Section B out of the bylaw for everyone who appears before us?
No, I don't agree with
So
that.
that we'd be treating people equally?
No, I would agree that you would have to review Section B and determine whether, in this case, there's a detriment to the neighborhood that's going on with the operation.
If I might,
Yeah, Mr. Alves.
doesn't the bylaw actually address this? The bylaw actually, if you look at the last paragraph of this section, it's just two sentences, I'll read it. It says, "No home occupation shall be conducted except in compliance with the foregoing conditions pursuant to a business certificate, or as otherwise authorized by special permit issued by the Board of Appeals pursuant to Section 3, subsection A, paragraph 7I," right? So we actually have standards we need to follow. And actually, I was hoping you could walk me through that, because I'm not sure that you've addressed, at least the standards that we're required to apply here, you're right, is the use incidental, but it goes on to say that the use must be not primarily industrial, trade, manufacturing, or commercial. I guess I don't see how we get around commercial with this.
I've given that some thought. I think it is a close call whether or not this is a commercial use or whether it is somehow something other in the nature of,
Does it make a difference that it's not a retail operation, that we don't have people coming and going, buying products, or?
Well, I don't know that it does. The question is, what did the town meeting mean? What was their intent when they restricted employees to those who were working in the house? So if I owned this house and I was a dentist and I wanted to operate a dental office here, and presumably I need a hygienist or some assistance, unless I married a hygienist or my daughter or son was a hygienist, I couldn't carry out a home occupation here. And the issue is, did the town meeting, when they required people to be dwelling in the premises, seek to cut back the use of premises for doctors' offices and dental offices and that type to more family-type, homey occupations as opposed to commercial enterprises? And, you just have to try to get a sense of it from reading it. But I don't think it necessarily, nobody has introduced any evidence, but we'll talk to some people, that you're engaging in an offensive use of the premises, that you're making noise, except for one neighbor here who says that he's having trouble parking and all of that. But you've got other neighbors, and I'll go into these. So nobody's raising that issue. The question is, what does town meeting say to this Board of Appeals when they say, we wrote a bylaw that says that the people who are engaged in the home occupation and employed there have to live in the residence? That's what we intended, and now you've rewritten the bylaw. That's the yin and the yang here as to how far the board can go, and Mr. Corcoran says that we can go there. And we'll hear from other people and decide whether we can. Mr. Gray.
Does subsection 10 even allow the board to issue a special permit? 7 does, but 10, the procedure, I think, is you go, you pay your fee, you register with the town clerk, and as long as you're in compliance with all of those subsections, you're granted the license to operate. I don't see anything in there that actually, unless it's in another provision that I'm not familiar with, that allows us to issue a special permit under 10. Under 7 we do, but I think we're running afoul of the commercial part of it.
Yeah, well, I guess the question is whether Mr. Corcoran is asking us to grant, well, I know he is. He's asking us to grant the special permit, then I presume with an unappealed, if that happens, special permit in hand, then he would march down to the town clerk with the special permit and with Ms. Page and fill out the paperwork and ask that it be granted. I think that's what the intent is.
that's the intent.
But your point is interesting. Mr. Alex, are you all set, so we can move on here?
We can move on.
Okay, great. Let me, we're spending a lot of time on our first application, but that's the way it is. Some of these letters are rather lengthy, so I'm going to kind of summarize the letters. We have a letter from Carrie and Michael McHugh of 18 St. Mary's Road. It's dated August 26, 2014. They write in support of Ms. Page's application for a special permit. The Page family has been friends of theirs for 10 years. They always respect the neighborhood. They add value to our homes and our lives, and they have complete faith that the business will be operated with the same values, and they offer their wholehearted support. So we thank the McHughes for their letter. We have a slightly longer letter from Carlos Rodriguez and Diane Rodriguez of September 10, 2014, speaking in support of
Thank
the
you.
application. They've been friends of the Pages for years, since they moved in 13 years ago. They've never been inconvenienced. They're respectful and caring at all times for the neighborhood. Parking has never been an issue with respect to their driveway. The business is quiet. They can never meet their clients at home. They always meet them in another destination. They add a degree of security to the neighborhood when most adults are away and working. They live next door, and the Pages are raising a lovely daughter. They've been wonderful neighbors, and they say that this business does not negatively impact the neighborhood in any way. Elizabeth Perry on 9/15 writes to the board. This is a little longer. They write in support of the application that Liz is a fundraiser for nonprofit organizations. She's a positive role model in running a successful small business. They first initially met at Cali Fields. Everyone knows the neighbors. They're wonderful neighbors. They've been in the office. It's an enthusiastic and friendly staff. The parking does not negatively affect the neighborhood. If this business was forced to move, they'd feel less secure and less connected to the neighborhood. Ms. Perry thinks that the presence deters intruders and porch pirates. I'm not familiar with that term, but maybe people who steal plants and chairs and things off of porches. She says that they're a positive part of the neighborhood, and she supports the application. We have a lengthy letter from Dr. and Mrs. Michael Duggan. It's dated September 8th, 2014, writing in support of the application. They've known Liz Page for 12 years. Wonderful neighbors, children play together. Putting aside the personal friendship, Liz's business is advantageous to the neighborhood. Milton has become besieged with home breaks and thievery of items outside of one's property. I guess porch thieves. We are fortunate we have not had any of those incidents. We believe that's part due to the fact that Liz operates a home office, which shows occupancy of the house. They have not heard anyone who is unhappy with Liz's employee parking on the street. They even said that the Colters are parking landscaping trucks around their property for long periods of time in order to mow the lawn at St. Mary's School, and that doesn't detract from the neighborhood either. So again, they emphasize we're happy to have the parking and the activity, and the ebb and flow keeps crime away. We believe Liz's business is a worthy asset to have in our neighborhood, and we hope very much that you will grant the permit that she needs to continue on St. Mary's Road. So and we thank all of those folks for their letters of support, and obviously we'll give them full consideration. If you have nothing more to add, Mr. Corcoran, let's see if there's anybody present this evening who wishes to, whether they have any questions of Mr. Corcoran or Ms. Page, or wish to speak in support of this application for a special permit. Yes, ma'am.
I'm Amy Nagel. I live at 8 Darby Road.
Okay, good. I'm sorry, just bear with us one question.
Your name again, I'm sorry?
My name is Amy Nagel. I live at 8 Darby Road with my family.
Okay, Amy, could you please come up here, and because this is being tape recorded and televised, and just speak up nice and loud and clear.
My husband and my 3 kids, we moved here about 2 years, a little over 2 years ago, and Liz and Marianne have always been great. I did not even know that they ran a business until all of this happened. I've never seen a car there. I probably get more deliveries than they do, quite honestly, for my kids. So they've always been wonderful. I don't see how there would be any harm in them having a business there. Like I said, there's never been any sort of issue. They're always extremely lovely whenever we see them, and they're just a great part of the community, and it would be a shame if they had to move. I mean, and it is nice to have, you know, the added security of people making deliveries, not just to my house, which happens all the time, so that, because we do live on a side street, so there's not always police officers who are traveling down our road. So now that I know that there's a business there, it's kind of, I'm home with my kids all day, and there has been a ton of break-ins lately, so it's nice to know that there are people who are home all the time who can kind of watch out for each other. So.
Great. Do you have anything else to add?
No.
Thank you for coming. We appreciate your speaking tonight. Anybody else who'd like to speak in support of this application? Yes, sir. Why don't you come on up here? Tell us your name and address, please.
My name is James Stone. I live at 228 Brook Road.
Good. Welcome to the Board of Appeals, Mr. Stone.
Thank you. I would like to say that I think it is important to understand the intent of town meeting when they made this rule, but I would also say that it's also important for this board to have some flexibility, because I'd like to emphasize the kind of business that Liz has. Even though it is not a not-for-profit itself, that it serves a purpose, a very important purpose for the not-for-profit community, which in turn helps us all. So I think it's very positive for the community at large and Milton itself, and I really haven't heard anything negative that would, or should impact the board making a positive decision.
Great, thank you very much for coming. We appreciate your opinions. Yes, sir.
Hello, my name is Mike Duggan. I live at 18 Derby Road. Fortunately, I'm not in front of the board for myself this time. I didn't realize my wife had written a letter, but my wife and I have been at 18 Derby since 2000. We've known Liz and her family since the fall of 2000. Personally, I can't imagine a small company being less obtrusive in a neighborhood such as ours. They have 3 cars, and again, mirroring what our neighbor said, if I didn't know that there was a business there, I simply wouldn't know. And I drive by there every day, and so I think the company is beneficial to our neighborhood, both as family friends, but also, as others have echoed, that they are eyes on the neighborhood during the day when we are all at work. So I'd just like to echo all the comments.
Great, thank you very much
Thank
for
you.
coming, sir. Is there anybody else who'd like to speak in support of this application? Okay, is there anybody present this evening who wishes to be heard in opposition to this application for special permit? Yes, sir. Why don't you come on up here and make yourself comfortable?
I'm Gary Simchek. I live at 203 Brook Road. I have the largest abutter next door to the business here. I read the bylaw, and I believe having people that employees work is against the bylaw. He's saying that maybe it's allowed. This is one business there, but actually there's more than one business there. There's 2 people who live there and work there all day, Liz and Mary Ann, excuse me. And they're both there with cars, and then these 3 cars come in. They tie up the front of the house every day. He mentioned they park on the private area, but there's only 2 parking spaces. And they're on the street every day. They're there when it snows, so it means the plows can't plow. The street cleaners can't clean the street. They have truck deliveries all the time, UPS, food deliveries. Some of the trucks are backing up. They used
Do you
to.
mean luncheon, when you say food, do you mean luncheon deliveries and things
No,
like that?
no, commercial trucks delivering food. It's one of the other businesses that are in this 3 St. Mary's location.
What are they delivering food for, do you know?
Commercial cooking it in the house to be delivered to parties.
Oh, I see what you're saying.
Yeah,
Okay, so they're using the house as a kitchen for
Yes.
for part of their events?
Yes.
Okay.
And, their trucks are backing up. Since in front of the house is tied up with employee cars, these trucks have to go somewhere else. They frequently park in front of people's driveways, blocking their driveways, because that'd be the closest place, but, sometimes employees were there, they yell out the back door, facing my property, for the kids to be, they bring their kids, and the kids yell at the kids to be quiet. so mommy can work, you know. I mean, they have a playground that's like an attractive nuisance. Sometimes the kids in the neighborhood are using it, and although they haven't been recently, but they were there for weeks at a time, sometimes late at night, and they seem to know when they're away. The other business, sometimes it's at midnight, 1 a.m., 2 a.m. They're outside on the deck, making noise or finishing, when they finish their business. There's, you know, there are employees who come from somewhere else. They have plastic,
Are these not the same employees
yeah,
that are
there's
there
another
during the
group
day?
of employees that come and cook, you know. And they have these big blue plastic containers. Sometimes they're on the back deck, sometimes they're on the lawn, sometimes they're in front of the garage. I believe I got a call from Mr.
Mr. Corcoran?
Mr. Corcoran, and he said the business is actually planning on to expand.
I don't think I ever, I don't.
Well, that's all right. We're here to judge the present business.
Anyway,
not to
I
speculate.
feel that it's a business that, if I was to buy a house, when I bought the house, there was no business there. They mentioned the doctor, he had died in like 1960, I believe, and there was an old lady, his sister, that lived there by herself for 30 years before I moved there. So there was no business there that I'm aware of. And if there was, I may not have bought it, and now that if there will be, maybe someone won't buy my house. I feel my property is affected, the price of my property is affected by this. I've lived in other towns, and I feel that one of the reasons I moved here is the enforcement of zoning rules.
When did you buy your house, Mr. Simchick?
1986.
Okay, do you have anything else to
I
add?
think that's it, I guess.
Okay, well, thank you very much
All right.
for coming tonight. Let's see if there's anybody else here who wants to be heard in opposition to this application for special permit. Okay, the record is there's no other such person. Mr. Corcoran, do you want to address just two issues that Mr. Simchick raised? That is whether the kitchen of the premises is being used for cooking for some of these social events that Ms. Page plans, and secondly, whether there are two groups of employees that come in to assist in the operation of the business.
Yes, there is Ms. Page's partner has a catering business that operates out of the Council on Aging, and she receives, at the end of the evening, materials come back and our equipment is stored in the garage. Employees come back at the end of a catering event. She has a separate catering business. It is a separate business. It doesn't operate from these premises, but they do use the garage, and they do, late at night, come back to those premises. But it is unrelated to the business that Ms. Page has.
Okay, and they're not using the kitchen in the subject premises in order to run a catering business, is that true?
Liz Page Associates is not. Her partner does use the kitchen, but she operates generally from the Council on Aging, and she does some cooking from the premises. But it
Okay,
is-
so the
it
second
is
group
not
of
a
employees that
different-
come in there are not from Ms. Page's
That's
business?
correct.
It's somebody else's
That's right.
business? What's the other business called, Mr. Corcoran, do you know?
Nibbles Catering,
How do you spell that now?
Nibbles.
Nibbles, oh, okay, thank you. And do you know how many employees come into the subject premises for
I don't.
Nibbles Catering? Is it 2 or 3 or 4? Or?
There are no employee, I'm the owner of Nibbles Catering, and I have no full-time employees. Oftentimes what will happen is there'll be, when we get done with the catering job, we'll unload, and so we'll be out on the deck chatting, as Mr. Simchick commented that, and that there may be noise that we did not know about.
Okay, do you use the kitchen for preparation of food?
Over at the Council on Aging.
Okay.
I entertain a lot though, so I do a lot of cooking.
That That's a right you're entitled to. You don't need a special permit from the Board of Appeals to do that. And just for the sake of the record, since you're part of the proceeding now, do you want to tell us your name?
Marianne Strodinskis,
Spell the last name, please.
Stravinskas.
Great, thank you very much. And do you reside in the premises?
Yes.
Okay. Okay, Mr. Alves, do you have any further questions there?
So point of clarification, so, Ms. Stravinskas, what is it that your business uses the premises for?
To store my pots, pans, cooking utensils.
It's in the garage
Because
space.
it's in the garage because we don't have storage over at the Council on Aging.
Mr. Gray?
One question. The employees during the day that work for your business, do they come in at 9 and leave at 5? Do they have to go in and out during the day? Is there a lot of...
It's not a
What's
lot.
their usual pattern?
Come in around 9, leave around 6, sometimes later, but pretty consistently.
And once they're there for the day, do they have to run out a lot, or they stay there most of the
Not
time?
very often. Sometimes. They ran out today. They had an appointment in town.
Right, you see clients, whatever. Okay. That's all.
Thank you. Mr. Corcoran, do you want to sum up, or have you had your say?
I think I've had my say, and I'm turning it over to the board.
Okay, well, thank you very much.
Before we go into deliberation, one other question. So the food preparation for the catering business, where is that done?
Council on Aging
Council on
building,
Aging.
which is over
Oh,
here.
I'm talking about your business.
Oh, I don't do food.
It's not catering.
Yeah.
So it's event management type?
Yes.
I see.
When it comes to.
Do you hire caterers or participate, allowing your clients to hire caterers for events and that type of thing?
Sure, sure. If we do an event at the Fairmont Copley Hotel, they do the catering, or the convention center or whatever, they do the catering.
Yeah, they plan large events for large nonprofits.
Thank you.
Mr. Alves, you all set?
Yep.
Okay, we're going to call to an end this hearing and end the evidence of the hearing. One thing I forgot to do, and I have to apologize. I want to apologize to Father Wright, because he also submitted a letter here that Mr. Corcoran referenced. It's dated September 11th, 2014, and I neglected to read his letter, and I'd like to just touch on it very briefly now. He says that Liz runs a successful business, engages in charity work, introducing friends to seniors who don't have many visitors. These are well-regarded, quiet, good neighbors, wonderful family in the community. The business is quietly run and unobtrusive, and Reverend Wright is pleased to support the request for, he says, an extension of the premises that would allow for the continuation of the business operating out of the home. And it's dated September 11, 2014. So we thank Father Wright for his kind letter. So with the evidence portion finished, we're going to deliberate on this application for special permit here and now and enter hopefully an appropriate decision. Mr. Gray, do you want to be heard first?
Sure. I guess I'm hung up, I mean, I understand the nature of the business and the amount of traffic, and there's much support in the neighborhood. I'm just, at the moment, I'm hung up on the particular section of the bylaw that we're looking at tonight, which lists, you know, a number of conditions for the operation of a home occupation. I don't know, it goes A through J. The B seems to be the one, that the only persons residing in the dwelling may engage in the home occupation. I don't see a lot of wiggle room there. And then the last sentence, which says, no home occupation shall be conducted except in compliance with the foregoing conditions pursuant to a business certificate, which is the section that we're talking about, or as otherwise authorized by a special permit issued by a board of, according to subparagraph 7. So I'm not, I mean, I would love to hear what you gentlemen think, but I'm, at the moment, finding it difficult to see how what kind of room we have to vary it under subsection 10.
Okay, Mr. Alves, please.
Yeah, I share the same concern. Even the end of the section you just read allows the board to issue a special permit, but subject to certain conditions. And one of them is that the home occupation be, one, incidental, and not be primarily commercial in nature. And I just can't get that. I don't see how this isn't primarily commercial in nature. Like you, I don't know that we have a lot of discretion here, and I worry that town meeting wrote it this way. What is the standard that we use when the next application comes up and someone's hiring someone in their home? We're going from certainty to the unknown, and I don't know that the bylaws gives us enough discretion to allow this. As much as I appreciate everybody coming out and showing support for the business, I see our hands being somewhat tied here. I can be convinced. And there's a fact that ought to not be missed. We're not asking for something to be started anew. This is a continuation of something that's been going on for a while. Very well presented, Mr. Corcoran, and I think that has persuasive authority in the way I think. Not allowing this would be a discontinuation as opposed to something being started new. So I'd like to hear your thoughts on this, Mr. Chairman, because I'm persuaded by that point, that while we may not have a lot of discretion to vary the terms of the bylaw, I'm also conscious of the fact that this is something that's been going on for over a decade, and there's substantial neighborhood support for it. I'm being ambivalent. So I'd welcome your thoughts in persuading me.
Well, look, I want to say several things. Number one, I want to thank Mr. Corcoran for his wonderful presentation. Ned always is terrific in gaining neighborhood support when he can, and presenting very cogent arguments in support of his client's position. I think that Mr. Corcoran couldn't have presented a stronger case for a special permit. That having been said here, I think that if you read the home occupation bylaw as a whole, and as it was presented to us by the town meeting, some of the provisions here are very, very specific. It's not like the ordinary special permit case that we have where we're looking at the effect of the premises, the improvement, the enlargement of the house on the neighborhood, whether it's going to adversely affect the neighborhood, benefit the neighborhood. We have a lot of discretion in those regards. As I see it here, we don't really have much discretion. I tend to think that the town meeting, when they put in Section B, were trying to restrict home occupations to a far less intense use than was previously taking place. But I don't know that as a fact. I mean, you just have to make inferences here. But they certainly did find that the employees can only engage in the home occupation if they're residing in the dwelling, a very specific comment. And I think that was to reduce the intensity of businesses. Now, here we have an application that does not meet the standards that the town meeting set for us. And I guess several things. Number one, we don't write the zoning bylaw, we enforce it. We're given some discretion to vary the bylaw when it comes to amorphous issues of the effect on the neighborhood and that type of thing. Here's a specific directive of town meeting. And my concern, and let me say this, Ms. Page, from everyone who's here and who has spoken on your behalf, who's written on behalf, runs a wonderful business and is a wonderful person. But we don't decide cases based upon wonderful people, because then we'd have no zoning bylaw, because I actually think that 95% or more of the people who appear before this board are wonderful people. They're great people. It's just that sometimes we can't give them the variance or the special permit that that they're seeking for a wide variety of reasons. So that without getting involved in the technicalities of the parking issues and all of that, I think the town meeting here was trying to restrict home occupations and not wanting home occupations to be bringing employees into the residence, and there had to be a reason for that. So I'm very concerned that if we ever granted this special permit, number one, the town meeting would say that we've usurped their authority. Who is this Board of Appeals? They're not rewriting the bylaw. They're not interpreting it. They're rewriting the bylaw. And I feel very uncomfortable doing that. And then, secondly, we're in the position of, and I don't want to make crazy analogies, but like opening Pandora's box. But if we do grant a special permit here, then I don't know how anybody can come before us seeking the type of special permit that Mr. Corcoran is seeking to have us grant and have us enforce Section B. I think we have to say, no, we've written that out of the bylaw with our decision in the Page case, and so that's no longer an issue, because I think that would be invidious of us. It would be discriminatory of us not to enforce this provision of the bylaw as it affects Miss Page, because she runs a wonderful business and she's a wonderful person, and it doesn't appear that there's a lot of problems with the neighborhood, but maybe there's some. But then denying somebody else because, well, we think your business is too intense, it's going to have a much more adverse effect on the neighborhood. Are we supposed to take Miss Page's case and use that as the standard? Well, if it's more difficult on the neighborhood, then it gets denied, and if it's less, then it gets allowed. But in any event, anybody can have a home occupation and bring in employees. I think that's crazy. I think the board puts itself in an untenable position going there. And I agree with Mr. Alves that Section 3A, 7I, while it's an interesting argument that Mr. Corcoran makes, doesn't get him there. So I don't think I can vote for this special permit because of Section B and the way this bylaw is written. Maybe this bylaw, and maybe there should be a debate at town meeting as to exactly what town meeting intends to do here, and whether this Section B should be part of the bylaw. But it is part of the bylaw, and we don't write it, we enforce it. So therefore, I respectfully have to tell you, Ms. Page, as wonderful as you are and all of that, I think I cannot vote for this special permit, even if I wanted to do it. I think when I took an oath as chairman of the Board of Appeals to enforce the zoning bylaw, I think I'd be giving a blind eye to the bylaw, and I don't think that's what we should be doing here. So that's my view of this. Mr. Gray.
I agree with you reluctantly, because we have to interpret the bylaw as it's written, not as we wish it were said. And if it had some language in there that allowed us to vary these conditions based on a given situation, I would feel that we would have the authority to do that. But as it is, it's fairly clear, and for all the points that you've said, I have to agree with you.
Yeah, and let me say this, and I mean this with all sincerity. There may be 50 other people out in Milton who are running businesses very similar to yours that are in violation of this bylaw. I don't know. We're not the RoboCops. We don't go around trying to find out businesses that are illegal. But if there are objections raised to any such business, they're going to get the same result as you had here. And I think if people like yourself, obviously a very successful businesswoman, if you think this bylaw goes too far, and I know you do, then I think that you, the business community, the town moderator, whomever it should be, should make that known to town meeting. And this bylaw can be amended, it can be altered. Regretfully, like the Massachusetts legislature, there's not a lot of legislative history. This isn't Washington, D.C., where you can go into a lot of hearings and find out what the real intent of the drafters were. The only way you could do that is perhaps go back and listen to the tapes of a 1995 meeting. But I think if you do not agree with this bylaw in the form that it is, you've got the perfect right to try to get this bylaw changed, and I'd urge you to do that. I don't know what the issues are. I take no position on this, whether the bylaw should be changed or rewritten or tightened up or loosened up, but I know this. This is the bylaw we're given, this is the bylaw we have to enforce, and I think that's what we have to do in this instance. So I've had my say. Do you have anything else, Mr. Alves?
No, like you, I'm reluctant in my view on this, because I do think that if you were applying for a new business, I don't think it'd be a close call at all. That the bylaw says what it says, and we can't deviate from it. I do feel for the applicant being in a position she's in, having had the business in place for several years, but as the chairman said, the redress here is through town meeting. I don't think our hands are tied. I don't think we have any discretion to decide any other way.
Well, and let me say one other thing from a practical standpoint. Whether we're a board of lawyers, I tend to practice in this area, and I can assure you that if we granted a special permit here and one of the neighbors appealed, not only would it cost you a lot of money, though I know Mr. Corcoran would give you a break on the fee, a Superior Court judge or a land court judge would reverse that special permit in about 35 seconds in the face of this. And I don't like to tell you I'm doing you a favor by denying your request for a special permit, because I know how badly you want it, but I am telling you that all you'd need is one of these neighbors to go out, hire a law student, and it would take 22 seconds to get this special permit reversed in light of the language of the bylaw. So I think that's the reality of the situation. So all those in favor of this application for special permit, please say aye. All those opposed? So I'm sorry you lost on your special permit application. It was the best effort you could have made. I can't think of any argument you could have raised, and I thought that you put on a wonderful presentation. So this this hearing is adjourned. Yes. Okay.
You read it?
Sure, if you want to. Great, thank you.
I just wanted to say goodbye.
Yeah, thank you. I'll move over in 3.
Cases like this, maybe we've been doing this too long, John.
I think we have,
I looked at this.
No.
I remember that decision.
but you wrote a wonderful opinion.
Well, I think you did.
It was a great opinion. I read it.
I'm not sure I wrote it. I think John may have.
Whoever wrote it did a great job.
No, John wrote it, but I
was a
remember,
little kid then.
I remember the case. Way back.
I was a pup. Mr. Corcoran, anytime you need a break or something.
I'm fine at the moment.
Okay, that's fine.
Thank you.
Just don't be bashful.
This is my week for this particular section of the bylaw.
Are we all set, Mr. Corcoran?
I'm all set, yes,
Okay, well,
thank you.
let me wait. Mrs. Fitzgerald has taken her leave. She'll be back in about 25 seconds, so we'll give her a break. Here she comes. We're going to call to order our second hearing of the evening. This is the 7:30 hearing at 8:23, so we're not quite on schedule. This is the application of John, is it Carney? Or Kearney? You say Kearney, okay. And Rosemary Hanley, the applicants. They own premises at 27 Garden Street in Milton. They're seeking a special permit from the terms of Section 6A3 of the bylaw. The applicants own 2 lots, and they propose to subdivide the lots, which I won't get involved in a lot of the detail here because Mr. Corcoran will as part of his presentation. And the purpose of the redivision of the lots is to make sure that one lot will be available for the building of a structure, and the house with the structure on it will be compliant with the zoning bylaw, and there won't be a need for a variance on that property. The applicants they intend to convey the new lot to their daughter and her husband to erect a dwelling on the lot. The Milton zoning bylaw requires that subdivisions of lots have to contain at least 6,000 square feet, 60 feet of frontage along a public way, and there are special provisions with respect to lots that are being subdivided that Mr. Corcoran will get involved in, which allows the board to authorize that type of subdivision by a special permit. So my name is John Leonard. I'm chairman of the Board of Appeals. With me tonight, to my immediate right, is board member Nicholas Gray, and to my immediate left is board member Emmanuel Alves. The rules of the board are going to be the same as at the first hearing. We'll hear from the applicant, people who have questions of the applicant, people who wish to speak in support of the application, and people who wish to speak in opposition to the application, if any. We're tape recording the proceedings. Tell us your name and address. Speak up nice and clear and loud so we'll have an accurate recording of the hearing. If we have to revert to that hearing in order to revert to the recording, obviously, if we have to prepare a written decision here. In addition to the application, the advertisement, which I just read, we have the application. It's dated July 31. We have a 2-page sheet from Mr. Corcoran enclosing a lot of exhibits, telling us the relief that he's seeking and setting forth the reasoning for his support of this particular application. Mr. Corcoran has some plans of the size of lots in the area. He seems to have a comparable decision that the board may have rendered a few years ago. In addition to that, we have a lot of building plans, the computerized plans showing the proposed exterior of the dwelling and the interior of the dwelling in multiple sheets. And also attached to this particular application is a decision of the Board of Appeals with a decision dated July 31st, 2005, where a special permit was granted to the John Mannion and Caroline Mannion at 257 Edge Hill Road in Milton, in an application that has some similarity to this particular application. So, Mr. Corcoran, a long-winded way to say welcome back to see you again, and we're delighted to hear from you.
Thank you very much, Mr. Chair, members of the board. For the record, Edward Corcoran. I am an attorney practicing in Quincy and representing John Kearney and Rosemary Hanley, who are husband and wife who own the premises at 27 Garden Street and the premises next door. I'm also joined by Brendan and Noreen Dolan. Noreen is the daughter of the Kearneys, and they who plan to build the new dwelling if the board were to grant a special permit. We are seeking relief under subsection 6.3 of the bylaw that addresses the issue of lots created before 1938, the enactment of zoning. I submitted several exhibits, one of which is the 1922 subdivision plan that created a substantial number of lots at Garden Street, Governor's Road, Warner Road, and Edge Hill Road. The locus is shown in yellow on those sheets. They are lots 5, which contains the dwelling, and lot 6, which is the lot to be divided. And the red hatch is the other 2 lots that were similarly situated, for which the board granted relief in 2005. The plan is to redivide. So as currently situated, lots 5 and 6 each contain 6,300 square feet, each contain 70 feet of frontage, which is allowable in terms of the division. However, there is a setback issue that exists with respect to the existing house on the side yard that the dwelling, as you can see from the plot plan that I've attached, would redivide from lots 5 and 6 to lots 5A and 6A, and that is to address an encroachment within the side yard setback that the shared lot line, where the existing dwelling encroaches within that 10-foot setback. I think the setback is actually about 8 feet. And so we've proposed to redraw the line. We'll need to, if approved, we'll have to submit to the planning board an A&R plan for their endorsement, but it would create 2 new lots. It would create a lot 5A, which would have an area of 6,590 square feet and frontage of about 73 feet. That would contain the existing dwelling. And then a smaller lot, 6,010 square feet with frontage of 66, almost 67 feet. In any event, that lot would exceed the minimum for which the board can grant a permit, which would be 6,000 square feet and 60 feet of frontage. I think the 2005 case is interesting because it's somewhat similar. There was a redrawing of lots. You see, attached to that decision, there was a plan that had been drawn by DeSalle Associates, and there was a redrawing of lots to address an encroachment for an existing detached garage in the rear corner of the dwelling, of the lot on the corner of Edge Hill Road and Garden Street, for which, and so they redrew to create, to meet the necessary setback for a detached building. They carved some land out of Lot 25, they gave some land back to Lot 26, and redrew those lots as 25A and 26A. I think these are, it's the same neighborhood, and they are similarly situated. And so it's a fairly straightforward matter. There are a number of neighbors here from the neighborhood who are in support of the application. I'm not aware that there's anyone who is in opposition, and so I would open it to questions of the board and address it as, leave it to the board for questions, and then we'll respond as appropriate.
Thank you.
Thank you.
I have one question.
Yes.
It's my distinct recollection, Mr. Corcoran, that the Mannion decision, which you've attached to this application as precedent, was the subject of an appeal.
Yes.
And it's also my recollection that that appeal was dismissed, voluntary or otherwise. But can you confirm for me whether that's true?
Yes, it is, and in fact, the special permit, although granted in 2005, was not recorded until 2008. It was recorded after the dismissal. So the recording information on the copy, which I downloaded from the registry website, indicates that it was recorded on April 22 of 2008. Could not have been recorded if that matter had not been resolved.
Do you know if it was withdrawn or if it...
I don't know how it was ultimately resolved, but it was ultimately it was dismissed or resolved in favor of the the permittees, those who granted the permits. There is a structure that has been built, a dwelling has been built on the lot, which is lot 25A. It's, when one looks at it, wonders whether the building itself complied with all of the requirements of zoning in terms of setback, height, and density otherwise, but there's no question that the matter was resolved and that the permit was recorded and a dwelling was constructed.
It's my memory that at least one of the neighbors who objected to the special permit application was a federal employee, and she was also an attorney.
Yes.
And I think that after a period of time, they decided to withdraw their appeal. I don't think it was finally adjudicated. Okay. But I just wanted to confirm that. Mr. Gray, do you have any questions?
Just, I think I understand, but is the net effect of this basically that we're just moving the dividing line a
Yes.
certain number of feet towards what will be the new 6A? Is that basically?
That's correct.
I haven't figured out how many feet, but 3 or 4 feet, so that's really all that you were looking for the special permit to authorize the redivision of the,
But
moving the lot line?
we are asking for a special permit to authorize
The
construction of the
construction, yeah.
dwelling.
Yep.
And a determination that the lot at 6,010 square feet
Is,
and
complies, yep.
66-plus feet of frontage complies.
Yep.
And so we were careful to redraw that lot line to make sure that it was large enough to qualify for the special permit.
Mr. Alves, please.
Briefly, did you submit a plot plan of the existing? Because in the application, it says that the current structure is within the side lot limits, right? It's not a big issue, I just want to,
I know I submitted the new one. I don't know whether I submitted the existing. I think I do have a copy of a plan.
that's the proposed, right? Where you look? If you don't have it, it's not a big point. I was just trying to understand that the sentence here in the application, so the current structure is non-compliant, and this would create compliance.
Correct. I think the current structure is 8 feet
Right.
from the side lot line. The minimum side setback is 10.
Gotcha.
So by moving 3 feet, we gave it an extra foot to bring the existing dwelling into compliance with zoning. We don't want to create did not want to create a new nonconformity associated with the granting of a special permit.
And that's the point I wanted to explore. So on the proposed chart, though, the lot 6A, and if you looking at the chart, the left side lot line, would that not be within 10 feet? It's like a porch or some structure, no?
No. The side of the dwelling, which is a,
Well, I guess I'm just looking at what's in here. You see the 10 feet demarcation here on the
oh,
proposed?
on the, you're talking, okay. That's a separate question. There are, and Mr. Prondak has opined on this, there is a chimney,
Oh, that's what that is.
and there is a bulkhead, concrete stairs that go down to the basement. And he's determined that those are not structures that are...
Purposes of measurement.
For purposes of measuring setback.
I have no more questions.
We have a separate question which arose and dealt with the front stairs and an overhang structure for the front stairs where they had proposed to install some columns and a small roof. If you see the front, first of the photographs, that actually does encroach. We didn't realize it at the time. Mr. Prondak and I weren't clear enough on that. That would encroach, and that would require potentially a variance from the front yard setback. So the applicants have determined that they will adjust the plans of the dwelling so as not to require relief from the setback. They have room to move the house back a little bit within the rear yard, and they'll work around with that, so that the relief will simply be for a special permit to allow the dwelling that will look like this, but will comply with the requirements of zoning.
And the existing dwelling is non-compliant because it was constructed prior to zoning, 1938, to the best of your knowledge?
I believe it was. I can't remember when the dwelling was constructed. I have
1925. Yeah.
Non-conforming.
That's before I was born.
According to the tax assessor's records, it was built in 1926. So pre-existing.
Great, let's see if we have any people present out there. Is there anyone out there who has any questions of Mr. Corcoran or who wishes to speak in support of this application for a special permit?
I'm Kate Sweeney Regan.
Okay, Ms. Regan, you're going to have to come on up here just a little bit. Otherwise, we won't pick it up on the television and they'll get mad at us. Tell us your name.
Kate Sweeney Regan.
Kate Sweeney Regan. Where do you live?
I grew up on 24 Garden Street, but I own 81 Garden Street.
Well, good for you. You're in the real estate
You like
business.
that?
Grew up at 24.
Trend's right.
And you live at, did you say
81.
81?
Yeah.
Great. We're delighted to hear from you.
We've known the Kearney family our entire lives, and they've always kept their properties in great order. And Noreen and her husband, Brendan, have gone above and beyond to make sure that the plans of the new house are, in relation to the other houses on the street, which is some ways more than that's been done in the past. The house that she's presenting looks just newer and nicer than the rest of our houses on Garden Street, but all I know
Can't help you there.
kills me.
Unless you want to buy
There's got a
new
little bit
house.
of green with envy here, but the house, it fits in perfectly with the neighborhood, and I think we all really appreciate that.
Right.
They're not really asking for anything, above, I think all of our houses are out of compliance, so she's doing better compliance than the rest of us.
Because it's an older neighborhood.
Yeah, all of our houses
Change
are, 1920s.
Great. Well, thank you very much for coming. We appreciate your comments. Is there anybody else who'd like to be heard? Yes, ma'am. Come on up, and we're delighted to hear from you.
Hello. My name is Elizabeth Bull. I live with my
How
husband.
do you spell your last name, please?
B-O-L-L.
Oh, just as you'd expect.
I live with my husband David, who's also here at 49 Garden Street. It's 3 doors down from the proposed lot 6A. I grew up in the house. We bought it from my mother in January. My mother had bought it in November of 1980. So she's known them since then. I've known them my entire life as well, and she attended college with Mr. Kearney. And the Kearneys have been wonderful neighbors. They take very good care of the property, and both inside and out. I went to high school with Noreen. She was 2 years ahead of me at Milton High. We played field hockey together. We're still very good friends. We very much enjoyed getting to know Brendan. And we read the letter. They're in compliance, and we're just excited to have them. I have a letter. I wrote one, and my mother wrote one as well.
Oh, great.
She was there for 32 years. Thank you.
Thank you very much.
Keep this set for me.
Yes. Okay, so these are multiple copies of 2 letters. Okay.
Apparently, yes.
We have 2 letters, one from Elizabeth and David Bowl, September 16th, 2014. Since we just heard from Elizabeth, we will accept your letter with thanks. And there's another letter from Eileen Donahue, dated September 15th. She was born and raised in Milton and is a resident of Garden Street for 32 years. She wants to express her enthusiasm for Noreen and her husband Brendan as they petition to build their home on Garden Street. Noreen grew up on Garden Street, and her parents have kept their home in excellent condition, both inside and out. She's positive that the Dolans will follow the wonderful example set by Noreen's parents, and that there is no doubt in my mind that they would show a pride of ownership in their home, too. And she provides her telephone number if we want to call her. I won't read the telephone number on the public record, but we certainly thank Ms. Donahue for her kind support. Is there anybody else out there who'd like to be heard in support of this application? Yes, sir, please.
Hi, I'll be very brief. My name is Richard Sweeney. I live directly across the street from the Cannies. I live at 24 Garden. That was my daughter that just recently spoke. We're very fortunate. It's like a family on the street, and we're strongly in support of such a good family as the Cannies. And I am hoping that this will be a positive experience, and you'll vote in affirmative for
Great.
this.
Well, thank you,
Thank you.
Mr. Sweeney, for coming. We appreciate your appearance here. Is there anybody else who'd like to be heard on this application for special permit? Okay, there's no such other person. Is there anybody present tonight who either has a question of Mr. Corcoran or otherwise wishes to speak in opposition to this special permit application? Thundering silence. Okay, so there's nobody who wants to oppose this application. Unless my colleagues have any questions of anybody. Mr. Corcoran, have you finished your
I
presentation?
am finished, thank you.
Okay, then we'll conclude the evidence portion of this application and discuss it in open session and hopefully be able to reach a decision on this controversial application this evening. Mr. Alves, please.
Thank you, Mr. Corcoran. Thank you, folks, for coming. In sharp contrast to the prior application, this one is squarely within the provisions of the bylaws that permits us to do exactly what Mr. Corcoran and the Kearneys are asking for. I think that the lots as described fit the parameters contained in the bylaws. They're between 12 and 15,000 square feet. They will have the required frontage and can be subdivided in the manner described. Very well presented, Mr. Corcoran, and the application is merit. A lot of support, obviously. I'd be inclined to vote in favor of the application, Mr. Chairman.
Thank you, Mr. Alves. Mr. Gray, please.
I would second Mr. Alves' comments. This one is directly within the scope of exactly what we're supposed to be doing under the bylaw. We're given the authority to issue a special permit in this situation, and I would be in favor of supporting the application.
Okay, well, I think the application was well presented by Mr. Corcoran. It's thorough, it's complete. It sets forth all of the technical reasons why the special permit should be granted by the board. A lot of historical analysis here, all of which we appreciate. And we also appreciate Mr. Corcoran citing this brilliant decision of the Board of Appeals in 1995. I wish I could tell you would probably remember that, but I'm not sure of that. But I did read this with some delight, because you always go back and look at decisions that you've written and participated in and wonder if you got it right. And here I know we did get this 2005 decision right. Mr. Alves was part and parcel of the decision. So, but I think it is a roadmap to the bona fides of this application. And these special permits always require discretion of the board. And I think the board is overwhelmingly in favor of this application. This is. There are times when you sit on this Board of Appeals when you feel badly, just like the last application. Wonderful application, wonderful people, but as I say, if we granted applications to wonderful people, you would need a Board of Appeals. But this is one that I would take great delight in voting in favor, and wish you all the best in your future dwelling. So all those in favor of granting this special permit?
Aye.
Aye. So congratulations on your special permit, and best of luck with the new
Good luck.
residence. Thanks a lot.
Thank you.
You want to do this?
I'll do it.
You all set on our third application?
I am,
Mr.
yes.
Corcoran? Okay, great. Ladies and gentlemen, we're going to call to order our third decision, I wish it were, our third application of the evening. This is the application of 50 Elliott Street LLC, seeking an amendment to a variance that the board granted to the applicants, so that the left front setback of the proposed I think it's a condominium structure,
An apartment building.
apartment building, thank you, be amended to provide 4 feet 10 inches of deviation from the front setback rather than the 6 foot as provided in the variance that the board granted in October of 2012 for the 27-unit apartment building at 50 Elliott Street. My name is John Leonard. I'm chairman of the Board of Appeals. Here we have Manuel Alves to my immediate left, Nicholas Gray to my immediate right. We've recited the rules of the board before. I think everyone understands them. The only caution is we're tape recording the proceedings, so be sure you speak up loud and clear. Tell us your name and address before you speak, so that we'll have an accurate record of the proceedings. So without further ado, Mr. Corcoran, welcome for your continued presence before the Board of Appeals.
Thank you very much, Mr. Chairman, members of the board. For the record, for this hearing, Edward Corcoran. I am an attorney practicing in Quincy, and I reside at 70 Morton Road. I'm actually in a butter to the property in question. And we went through, on behalf of the applicant, 50 Elliott Street LLC and Milton Hill Partnership, went through a fairly extensive process in 2012, pursuant to which the board granted a set of variances from height, setback, density, use, et cetera, to allow a 27-unit apartment building to be constructed on the land below the existing Hill House and fronting on Elliott Street. In addition to that, there was to be a restoration of the Henry House, which is an old historic house on the property, and construction of a new small carriage house with an additional unit, so that the total number of units would be 30, 27 in the this new large building, 2 in the Henry House, 1 in the carriage house. The setback among the relief provided was the setback from the front yard, which is the frontage of the building is Elliott Street. And I provided a series of exhibits. Exhibit 1 is a photograph, is a rendering of the building as it was appeared when the board granted its relief. And on that frontage of that structure are three attached sets of balconies, porches that were going to be attached to the front of the building. As you look to the, facing the photograph, the relief relates to the setback, the closest point of the building to the front yard was about 6.5 feet, and it was on the decks that were furthest to the right. Okay. As we move from the granting of the variance through site plan approval, and we conducted process with, both with this board, with the selectmen, with the planning board, as we moved, and with their recommendations, the board voted to grant the variances. As we moved from the granting of the variances to the formal process of site plan approval, which was granted in January of 2013, there was a modification to the design of the front of that building. The members of the planning board did not like the appearance of those decks. We had quite a number of, several meetings where we dealt with the issue of decks. And they settled upon a new design, which is shown in Exhibit 2. It actually is just renderings looking at it from slightly different angles. But the new design shows a covering along the frontage of the building, covering the first floor level of decks above with some other roofing associated with it. And unfortunately, at the time that that was being redesigned, the team lost track of where the setback was. And the building has actually been constructed. It's now ready for occupancy. And an as-built plan submitted to the building commissioner revealed that the corner of the roof overhang and the post on which it sits on the left-hand end is actually within the encroachment by about 1 foot and 2 inches. So it's 1 foot and 2 inches closer to the lot line. The sidewalk actually curves slightly along the frontage at that location, and the as-built plan depicts that. That's Exhibit 3. It depicts that slight curve, and you can see on Exhibit 3 where the column that supports that corner of the roof overhang is located. It is that column that Mr. Prondak has determined to be out of compliance with the zoning. We're left with a couple of options. One is to sort of take the column out and cut that roof line back by about 1 foot, which would create sort of a jagged look to it, or seek an amendment to the variance to allow the setback to be at 4 feet 10 inches for the column. The overhang itself is 3 feet 10 inches, but that would be allowed as an additional 18 inches under the exception to the bylaw that addresses roof overhangs from setback. The client is prepared to go in either direction, but we went back to the planning board, and the planning board voted to support the application for variance. They thought that the appearance from Elliott Street would be would not be as attractive as it is, and because they really drove, the planning board really drove the change in the design, they felt like they really needed to support it. I know that they voted at a meeting in August. I know that Bill Clark was requested to be present and to express his support. I know that he's in the building at other meetings. I don't see him present in the room, but I know that I can represent that I was at a meeting with the planning board when they voted to support the application. And so With that, I would ask the board to grant the relief requested.
I have two questions, Mr. Corcoran. Can you tell me approximately when the planning
It was
board
the first Thursday
so
night.
voted?
It was the first Thursday night in August. It was, I can tell you in a moment. I think it was August, it was their first meeting in August, which I think was August 7th.
Do you know why the planning board didn't favor us with a copy of that vote?
I don't, and I apologize myself for not securing a copy of that vote, but I know that Mr. Clark was directed to express their support to the board, and I just didn't follow up and make sure that I had that for the record.
Well, you presume Mr. Clark was going to be here?
Yes, and I saw him today, and I saw him this evening. He's in the building.
I saw him too. Prior to the beginning of these events, Mr. Clark did take me aside, and that's why we went into the back room. And he wanted me to be assured that the planning board had so voted, even though he didn't have a copy of the vote with him. And he also wanted for me to put on the record, because apparently there's a warrant committee meeting or something downstairs that is demanding his attention. So he was going to be running up and back and forth, but I haven't seen him out there in the past 20 minutes or so.
I did understand he had other business in the building that he was required to attend to.
Right, so he wanted to be sure that he was recorded as town planner in support of your application for variance. And I told him I'd put that on the record if he was unable to be present.
Thank you.
Let me see if my fellow board members have any questions. Mr. Ells?
I do not.
Mr. Gray? Is there anybody present this evening who has either questions of Mr. Corcoran or otherwise wishes to speak in support of this application for variance?
We have something to say. It's not in support or against. It has something to do with the entire project.
Sure. Well, why don't you come on up, and we're
Okay.
delighted to hear from you.
Hi, Ned.
So,
Hi, Danielle.
you know, our present issue here is this narrow issue of whether to grant the zoning relief, but
Yes.
go ahead.
So maybe it's in
Why
a...
don't you tell us your name, please?
Yes, Danielle Chauvet, and I live at 12 Morton Terrace in Milton. Excuse me?
Spell your last name, please.
Chauvet.
Thank you.
Okay,
We were not proficient in French when we were in high school. We apologize.
that's okay.
Go ahead.
So I don't even know if it's appropriate to be here tonight, but Ned did
It's a
mention...
public hearing. We're delighted to have you. We don't
Yes, thank you.
We don't want to be overly technical.
So this whole entire project started back in 2010, and that's why my husband and I are the only ones left standing in the neighborhood here tonight, because I think everybody else is just so tired of this. But the building is built. It is better than what was there before. But as a neighborhood, we were promised certain things with the building. We negotiated for years on how this was going to come about, and there were certain things that were promised. And the reason why we're here this evening is Morton Terrace was a dead-end street before the development and remains a dead-end street. But when we were negotiating what was going to be at the end of our street, we decided on a gate that was going to be close to the development, meaning that our street would remain a dead end and that there would be no access to Morton Terrace from the new development.
Except in
And-
emergency circumstances.
And so we needed a fire, the fire department, because we do have a fire hydrant in front of our house. It was determined that there would be a gate, but that it would be a fire access. If need be, a fire truck could pull up in there for the carriage house that was built and for Miss Henry's house, which is the existing older house that we also fought to keep, not to be torn down. So the gate has been built, and it's a disaster. It's not at all what we were promised. It's not at all what we imagined, to the point where there was one of the fire department men who came the other day, one of the inspectors, because the lock to the gate was put on the wrong side. It's not on the side facing our street. It's put on the side of the development, which means the purpose of the gate was so that the fire truck could access the property, and yet the lock is in the inside. And this is revealing because, in my opinion, this shows the lack of attention and thought that went into this gate. This gate was just thrown up with cheap material. It won't last. It will be an eyesore a year from now, if not earlier, because it's already warping. And it's just really, really disappointing because we asked for so little in this project. We knew it was going to go through. We knew it was going to happen. And the one thing that we wanted was that our street was going to remain a dead-end street, and that we were going to have something attractive at the end of our street instead of an eyesore. And it's really, really minimal what we wanted. And it's an insult, this gate that went up. And when the fire chief came the other day to confirm that the lock was on the wrong side, he said to me, "You must be really disappointed in this gate." And I was like, yes, we are really disappointed in this gate. And the other thing that's really disappointing is that we had decided that it was going to be a cedar fence, and what went on along the entire periphery of the property was a PVC, I don't know if you say that, plastic fence. And we had asked specifically for something that was in cedar and attractive. We even submitted photos of wall pool fences. And when I saw the plastic fence going up, I called repeatedly for days, and nobody returned my call. And I sent emails saying, "I just want to make sure that that's not the gate that's going up at the end of our street. We decided on a cedar fence." So what happened was the fence that they started to put up around the periphery stopped, dead in its tracks. Then they built the fence at the end of our street, and it's not finished. The plastic fence stopped, the cedar fence went to a certain point, and then there's a hole in between the two fences. So our street is not technically closed off. People can go through there if they want. True, they have to scale a little mini wall. But it's not at all what we were promised, and I came here tonight to express our disappointment with that when I feel like we asked for so little, and now they're asking for a variance, which is a done deal, I imagine, because it's already built. And the building is really too close to Elliott Street, but I'm not here I'm not here in support or against the variance. I'm here just for the record to say that I feel like we got gypped on what we were promised.
Let me ask you this, because what you're asking us is, it's outside of the scope of the variance here, as you probably
I
know.
understand that.
But did you bring these grievances to the attention of the planning board?
No, I didn't. I mean, I guess I didn't know the proper channels to go through. So I came this evening because I did ask Ned to come down one day, because Ned is my neighbor, and I like Ned very much. And I asked him to come and look at the fence, and I asked him to honestly tell me what he thought about it. And
Well, okay, we don't want
yeah.
Mr. Corcoran's comments on the fence on the record, but
Okay.
I think we appreciate you coming tonight. I think that Mr. Corcoran will probably bring this to the attention of appropriate officials who are involved in this. But if you have difficulties because you don't believe the the gate is appropriate, that's certainly within the jurisdiction of the fire department to require a gate with a proper lock and a gate that's going to work. But also you could bring this to the attention of the planning board. They're usually very solicitous of neighbors who have concerns, and particularly if representations were made to you that certain things were going to be done. Nobody will want a PVC fence and a cedar fence and a hole in the middle. I mean, it looks and sounds ridiculous. So
it's unfinished.
yeah, well, I think maybe that's on the punch list. Maybe it isn't. Maybe somebody has to be told to put it on the punch list, but I think even though this is not within our jurisdiction at the present time, that you certainly should be working with Mr. Corcoran, because everyone likes Ned because he's well-intended and he's a man of integrity. But if, for whatever reason, Ned's clients won't listen to his requests, or you're still disappointed, then I think your remedy is, first of all, to the fire department regarding the quality and the nature of the fence, the gate, and where the lock is and all of that. But secondly, I would informally speak to Mr. Alexander Whiteside, who's the, I think he's presently the chairman of the planning board. They revolve every year or two. And he would, I know would be delighted to talk with you, even informally, to see if he can get some action to have this property finished in an appropriate manner.
Okay,
And
so
then-
it's with Mr. Whiteside I need to
Yeah, I
see.
think, well, I'd work with Mr. Corcoran to start out with, and I'm sure he's glad to help you, but then if you're not getting the type of thoughtful response that you think is appropriate, I would certainly talk to the planning board, and if you're not getting a response there, you have the right to go to the selectmen, and so you have means of redress, and my
Okay.
guess is that everyone wants this finished in an appropriate way. It may be they're just rushing to get the main building constructed and finished so they can start to rent it, and maybe their priorities are focused in a different direction at the present time. I don't know, but I think those are your real avenues of redress.
Okay,
And I have every confidence that your issues are going to be addressed,
okay.
okay? But and thank you for coming this evening, because it may make it an issue on Mr. Corcoran's agenda.
Okay, thank you very
Okay?
much.
Great,
Thank you.
thank you for speaking tonight. Yes, sir.
Hi, I'm Will Chauvet. 12 Morton Terrace. I am surprised that the variance, they're asking for a variance even after the porch being built. I thought things were done around. It sounds very much like the way things are done in France. I'm a little surprised, frankly. And so the question now is, okay, if that's the way they do things, what's next? That's
Well,
my big concern.
Yeah, I think what tends to happen here is that they have these working plans, and but when you finally get your as-built plans, which they need sometimes for financing and maybe for town building purposes, you can find some slight variations in the plan, and it arises really from a combination of factors, but part of it's the curve in the road, and you're only talking about a foot or a little more than a foot, so it's very easy not to notice that until you're looking at this particular structure. Perhaps with some type of a laser device. I've forgotten what you call these sighting things. Transits, are they?
Something like that.
Yeah, no, but no, we've had a gentleman in here a few years ago, and he was buying a very expensive lot, and when he took the meets and bounds descriptions, he took previous plans that were on file, all of them showed the lot to be compliant, and yet for financing, they wanted another plot plan, which they probably should never have done, but they did, and a very good engineering firm went out there with laser transits, and they found that there were deviations in the lot area and in the dimensions of the lot, so they needed zoning relief from the Board of Appeals, and it was just because of the advances in the technology, that if they had used the earlier site plan, everything would have been fine, but it wasn't. So I think these things do happen every once in a while, and it's unfortunate. I think the last thing the applicant here wants to do is to advertise and pay Mr. Corcoran his fair fee for coming here on a matter that everyone thought had been taken care of. But we also had a gentleman who was he had a house, I think it was a $2 or $3 million house up on Upper Canton Avenue, brand new construction. This gentleman was the builder of the place, and before he could sell the place, he found that it was like 4 or 5 inches off. There was a deviation in the lot line that caused a dimensional variance of 4 or 5 inches. He just wanted to cry. But again, it was modern technology in engineering that showed there was this deviation. He had to come in and get a variance from us so he could sell his house. So I think that's probably what it is. It's unfortunate, but it tends to happen in the business. And we're sorry he had to be inconvenienced to come here tonight.
Problem. No further questions.
Thank you for coming. Thank you. So is there anybody else who'd like to speak regarding this application? And there is no such person present. So, Mr. Corcoran, if you have nothing further to add, we'll end the evidence of this particular hearing and see if we can discuss it in open session and vote on it here and now. Mr. Gray, please.
Well, while I'm a little concerned at how close the porch actually ended up to the sidewalk, I drove by it, I mean, I drive by it all the time, drove by it again tonight. Given the choice between granting the variance and leaving the structure as it is and chopping off so that it complies, and thereby looking awful, I think the town would probably prefer for us to grant the 1 foot 2 inches or whatever it is, so it would the variance. So I guess I would have to be likely to support the application.
Mr. Alves.
I agree. I think the request is minimal, well presented. I think it would be a shame if forced to chop it off, to quote my colleague, and have an unfinished building. So I'd be inclined to vote in favor of the application.
Okay, well, look, I agree with my colleagues. I think this is unfortunate, but it happens. Nobody's perfect, and there's a confluence of unfortunate circumstances here, which really requires a very minor deviation from the previous variance. And I'm sure this is the last thing that the owner wanted to do, and certainly the last thing Mr. Corcoran wanted to do. This is an exciting project. This area of Milton is exploding, in part by high-quality developments, such as this type of development. And we granted extraordinary relief to allow this apartment complex to be built, because we thought it was tasteful and it would be great for the neighborhood and be great for the town. And it was supported by the selectmen, the planning board, and everyone in creation. And it looks, in my mind, terrific. So I have no difficulty whatsoever voting in support of this variance. And I just request that Mr. Corcoran see if he can be of some assistance in making the Chauvets happy and supporters of this project, as I know you and the owner will. So all those in favor of this application for variance with the usual conditions, say aye.
Aye.
Well, congratulations on your variance.
Thank you.
Appreciate it. Thank you.
Good night. Thanks.
Night. David? Oh, yeah.
Mr. Corcoran, you all set for the fourth hearing, or
Yes, I
a
am.
few seconds to get on?
No, I'm all set, thank you.
We're going to call to order our fourth hearing. This is the 8 o'clock hearing at 9:18 in the evening, and it's on the application of David and Meredith Hall, seeking variances from the terms of Section 5A1 and 6E3 of the bylaw. The Halls are seeking to construct a three-story addition to the right side of their existing family residence, which is located at 41 Russell Street in Milton. It's located in a residential B district. They're also seeking to construct a detached garage, replacing a garage that they had previously demolished as part of the proposed project. The proposed addition of the house violates the height provisions of the bylaw in one of these usual circumstances where the basement is considered a story, and then you're into 3- and 4-story residences. And the Halls want to improve their property with a porch, which Mr. Corcoran will get into in some detail, that violates the gross floor area portion of the bylaw by 184 square feet. So, my name is John Leonard. I'm Chairman of the Board of Appeals. With me tonight, to my immediate left, Emmanuel Alves, and to my immediate right, Board Member Nicholas Gray. Rules of the board are same as all of the previous hearings. We're tape recording the premises as usual. So, Mr. Corcoran, if you're up to it, we're delighted to hear from you in support of this application.
Great, thank you very much, Mr. Chairman, and delighted to be back again this evening. For the record, Edward Corcoran, I'm here on behalf of David and Meredith Hall, who joined me at the table. They reside at 41 Russell Street, and this is one of those, I find this a fascinating project to think about. This is a pre-existing non-conforming dwelling in a pre-existing non-conforming neighborhood. And only one of the dwellings within this neighborhood complies with zoning today, and that is the house directly across the street from the Halls. It was built in the 1970s to comply with current zoning. The Halls have taken photographs of all of the houses within the neighborhood. They are all non-compliant for various reasons, height, setback, and otherwise. And it is a magnificent neighborhood. The nature of the architecture is unique. It is typical of Milton Hill, the neighborhood that we're located in, and I am up and around the corner and in a similar street where Victorians and Federals sit side by side. You couldn't build those today substantially under current zoning. And I think it is a shame the way the zoning has been written to suggest that you can't replicate some of what the beautiful neighborhoods that exist. But this is a great neighborhood, and they are simply looking to update and modernize an existing dwelling that is non-compliant. I think, and so there's a couple of things. One is an aerial. It depicts sort of the rooftops and the sizes of the dwellings, as you can see from the aerial. The next is from the town's website, it's sort of a plat plan, and I've asked the Halls to put in the dates of construction of all of the dwellings, and with the circling the address, and then note the dates. 1879, 1910, 1890. This dwelling was constructed in 1890 at another time. The next is a side-by-side, really the relief. There's two components of the relief, but the significant component of relief that's being requested deals with height. And the existing dwelling, as it is depicted on the left-hand side of this plan. And there was a garage, an attached garage on the right-hand side. That garage has been removed. There is a new garage that is constructed in the rear, and the first of the photographs, which is of the dwelling, shows a new garage that is constructed in the rear. That was constructed in the rear substantially then to make way for the proposed improvements, which is a new 3-story addition to match the character of the remainder of the dwelling. Because the first floor elevation exceeds, is at a height greater than 4 feet, we have a 3-story, full 3-story addition. And the existing height is at 42 feet. It's non-compliant with this existing zoning. They could bring it down to 35 feet, but would be an odd sort of addition. It wouldn't blend to the existing ridge of the roof. In addition, because the garage was built as a detached garage, it was done with a permit, when they went to design sort of and the last page here shows sort of the deck. There is a beautiful wraparound deck that wraps from the front and around to the left-hand side as depicted here. I want to take that further around the back. It is one of the real architectural features of the dwelling as it exists, and it's something they want to add. They were advised by Mr. Prondak that the deck, when they measured out the square footage, both from a gross floor area and from a lot coverage perspective, that they were now going to be non-compliant with the bylaw with respect to those two items.
So is it, sorry to interrupt, is it the porch that causes that violation?
Yes.
So without the porch, with the addition, we'd stay within the...
We'd stay within the, right, and the way the bylaw operates is, it's what the bylaw is, deals with the ability to add a detached structure.
Right.
And that's when you trigger
I got it.
gross floor area and lot coverage. If it were attached, it wouldn't be an issue.
Yep.
But because it's detached, it creates a nonconformity. They've been advised, because it is a wooden deck structure, that it would require variance. If they added some fill and created a stone structure, they've been advised by building commissioner, that it wouldn't trigger the need for variance. So the definition of structure plays here. And that would be out of character with what else is here. We have a series of letters from neighbors, the most eloquent of which is from Bella English and Fran Bailey, who live directly next door, and really speak to the architectural intent, the preservation of the character of the building with respect to how it sits within the rest of the neighborhood. There is tremendous support among the neighbors for the improvements that the Halls are proposing here. I think it is more in character with the nature of the neighborhood, with the nature of the dwelling itself, to do something that is, for which a variance could be granted, as opposed to do something that is, would be compliant with zoning. There is a slight grade issue that is, in part, contributes to the 4-foot first floor elevation, although many of these, and many of these dwellings were built with that elegant walk-up to a higher elevation. I would note that just as an aside, that town meeting is going to take that issue up in October. There is a pending a recommendation for an amendment to the bylaw that it was been submitted by the planning board to change that elevation definition from 4 feet to 6 feet for dwellings that pre-existed 1950.
Long overdue.
You're trying to put us out of business. We have 40 of these applications.
It's a little bit to my own economic disadvantage as well.
I don't need
Careful what you ask
I
for.
don't need you to get that kind of variance. They just have to show up.
So, but there is a pending bylaw amendment that will come before town meeting in October. Unfortunately, it won't have been passed in time for the halls to take advantage of it. So with that, unless there are questions or concerns, I would ask that the board support the application.
Okay, let me see if my colleagues have any questions. Mr. Alves?
Not a question, but a comment. When I first read this, I was struck by the magnitude of the request. But I drove through I can't believe I've never been to your homes, guys, or driven by. But I drove by it, and anywhere else, this would be a very different request, I think. But I agree that this is the nature of the properties in this area in terms of, and one thing I was hoping you would tell us is whether any of these were added on, or, so in this map here, which is actually a good view of it, knowing the positioning of these properties within the lots, any way of knowing if these are original constructions or just more of a curiosity than anything else, because they're beautiful, stately buildings.
Yeah, I think a number of cases, accessories were added. I know the Chuck Tuff's, your immediate abutter on the other side, where there's, you can see that there's a garage structure that abuts, that was added. In fact, Mr. Hall told me that he and Mr. Tufts talked about whether or not they should have gotten relief from the sidebar setback, for the setback from the garages, so that they could come closer, actually, and conjoin, and therefore not have space in between where difficult to maintain, where, you know, things can happen. So, yeah, I think, I didn't do a specific search with respect to other variances or modifications in the neighborhood. This is a neighborhood that does, predates the turn of the century substantially, and it's the way the neighborhood was developed.
I mean, the usual questions, obviously this will be done, it will be in conformity with the existing structure, you're not going to paint it purple or anything crazy. I have no other questions.
Okay, Mr. Gray.
I have no further questions.
Okay. I don't have any questions. I just want to express a disappointment. I really wish, even though it's irrelevant to our decision, that she had some photographs of the interior of the property.
It's beautiful.
The exterior is wonderful, and I'm sure when you finish your improvements, it's going to be wonderful, but I just love to see what's inside. It looks great.
Beautiful home.
Let me, for the sake of the record, just indicate some of the assents that we've received. We have a letter dated September 12, 2014, from Jane Tufts and Charles Tufts at 49 Russell Street, supporting the application. We have a letter from Bella English and Fran Bailey of 33 Russell Street, with a letter of August 27, 2014, in support of the application. We have a letter dated September 9, 2014, from Matthew Kelly and Christine Kelly, supporting the application. The Kellys reside at 42 Russell Street. And we have a letter from Audrey and Tom Gavin, Gavin, of 34 Russell Street. Their letter is July 26, 2014, supporting the application. We have a letter of September 10th, 2014, from Mary Margaret and Mike Jacobzak of 6 North Russell Street, Milton, in support of the application. So we thank all of the neighbors for their consideration and writing letters. Let me ask, is there anybody present this evening who has any questions of the applicants, of Mr. Corcoran, or who otherwise wishes to speak in support of this application? Yes, sir, please. Come on up here.
I'm a non-writing supporter. I'm not a non-letter writing supporter.
That's all right. We're delighted to have you. You're long-suffering, I can tell you that. Tell us your name.
I think I came for the 50th anniversary of the Erie Pub for this.
Well, I hope you're going back there when you finish. No.
My name is Paul Kostka, Kostka, and I live at 176 School Street. I'm a direct abutter in back of the house. And I wanted to, you know, I have an 1848 house, so I know how difficult a house of age can be. So I have total faith with, you know, what they've done. You know, they have a garage that's now giving me more seclusion and privacy. And I'm sure whatever they're gonna do, it's just gonna be fine, because I've seen the plans and I'm totally supportive of upgrading the whole neighborhood that are just obviously there for old code reasons or whatever.
Great. We appreciate your long suffering and your appearance tonight.
No suffering. No suffering. I was more interested in the process, too.
Great. Thank you very much. I just have, can I ask you 2 questions? Are you doing this yourself, or are you hiring a builder, or?
Hiring a builder. Yes, sir.
You are a builder?
No, we are hiring a
Oh, you're
builder.
hiring a builder, okay, okay. And I take it you need your variance as soon as you can do it, or?
Yes, sir.
Are you doing interior work now?
Yes,
or-
you asked to see the interior, and it's entirely gutted already, so you don't want to see it now, but yes, sir, we've begun.
Construction.
Okay, so
Yeah.
you'd like to get the exterior finished before the snow starts to
Yes.
fly and all of
The
that?
addition built and closed in before the worst of the winter. Yes, sir.
Okay, we'll try to do our best there. I think I asked, but just for the sake of the record, let me be sure, is there anybody present here this evening who wishes to speak in opposition to this variance application? And there's no such person present. So unless you have anything further to say, Mr. Corcoran, we'll close the evidence and let's discuss this decision. Mr. Alves, please.
Well, thank you, Mr. Corcoran, for suffering through these marathon sessions and for a very good presentation. I think the application has merit. There's obviously unanimous support from the affected and abutting neighbors. It's not an insignificant request, but I think given the character of the neighborhood, and I had the pleasure of driving through. I live in Milton for 20 years. I've never driven through that part of town. I don't know why. I'd be inclined to vote in favor for all those reasons.
Okay, Mr. Gray.
I also would be inclined to vote in favor of this application. I think this is one of those situations where you could build something that would comply with the zoning that would end up looking worse. And I would hate to see a Victorian house of this, stature remodeled, if that's the right word. So I would be inclined to support your application.
Well, I think the application was very well presented. It looks like an exciting project. You have unanimous neighborhood support. The only trepidation I have is sometimes I watch these renovation shows on TV, and you see when they start to pull apart older dwellings, some of the courage it takes for the owner to persevere with the types of improvements that they're doing. And I hope you have the very best of luck when you open up walls and do other things. But it certainly, it's a wonderful neighborhood. And I think Mr. Alves made the telling point. While from an arithmetic analysis, you can say, well, this is a fairly, forget the height, that the volume of the property, it's a little more than, it would cause concern sometimes on these applications, but on this one it doesn't, because the character of the neighborhood indicates that this type of improvement and this type of porch is readily found in the neighborhood, so it's...
This was a good idea. Actually,
The photographs were terrific.
That's the impression I got. I walked away from, but I'm glad you brought it. So it was good.
And I think that's telling. You have to look at the context of the application, and this one is well presented. It has great merit, and I hope a lot of other people in the town who own dwellings like this have the courage to update them and improve them, because they're part of history, and exciting place to live, I think. That's wonderful. Congratulations on your variance.
Thank you.
All those in favor of the variance, please say aye.
Aye.
So congratulations, and
Thank you.
we'll see if we can find somebody to crank this out
do it.
before the frost. How about before the first frost?
Thank
okay?
you.
Sounds great.
Thank you.
Good luck with the improvement.
Good luck.
Thank you, Ned. Thank you. Okay, no other comments. We'll be adjourned. Thank you.